What can you do when government actors abuse their powers? I've talked before about the right to petition government for a redress of grievance and how the judicial precedent of sovereign immunity violates that right. But what happens when law enforcement or the Justice Department abuses their prosecutorial powers? How do you seek redress for a malicious prosecution? For years, it has been extremely hard to do so, but a recent Supreme Court opinion may balance the scales. So we'll discuss that next on the Constitution Study.
There's one thing you have to know wherever you make your stand. Came from a long through line of everyday Americans.
Hello there, everyday Americans, and welcome to the Constitution Study. I'm so glad you could join me. Listen, I'm putting together my 2022 tour dates. Now, I'm still looking for dates and locations, but if you want to find out more, head to the website constitutionstudy.com/tour. I'm still building that page out. It still shows a lot of stuff from last year's tour, but that's where I'm building it out. And one of the things you can do is find out A, where I will be, and B, invite me to come speak at your event or to your group. Now, I'll be talking about this as it goes along and probably a bit more at the end of the video. So for now, let's talk about this case in New York City called Thompson v. Clark. The case we're looking at today is Thompson v. Clark et al. I want to look at this case from the point of view of the three sides involved: the parents, the emergency medical technicians, and the police officers. Now, the story starts with a misunderstanding. On January 15th, 2014, petitioner and Talita, I hope that's how I pronounce her name, then his fiancée, were the proud parents of a one-week-old daughter, Nala. That day, they brought Nala to her first checkup where she received a clean bill of health. At around 10 p.m., the couple was at home and ready to sleep, dressed only in their underwear. Now, unbeknownst to the couple, Camille dialed 911. She stated that Nala often cries when petitioners had changed her diapers and that she had seen red rashes on Nala's buttocks area, commonly known as, and later confirmed to be, diaper rash. Mistaking these for signs of abuse, Camille provided a description of petitioner and his address. Now, as a parent, I have sympathy for Mr. Thompson and his then fiancée. They were preparing to go to bed when, unbeknownst to them, Talita's sister Camille calls 911, apparently mistaking a crying baby and a diaper rash as signs of abuse. In response, two emergency medical technicians, EMTs, arrived to petitioner's apartment building to investigate. The EMTs met Camille outside the building and she led them into the petitioner's apartment unit. Once inside, the EMTs saw Talita holding Nala safely. Petitioner entered the room and asked the EMTs why they were in his home. Unaware of Camille's 911 call, petitioner informed the EMTs that no one in his home had called 911 and they must have the wrong address. Petitioner asked the EMTs to leave, and they did. A report of potential child abuse is taken very seriously, as it should be. So two EMTs were dispatched to investigate. Now, at this point, no one is aware of the misunderstanding, although the EMTs would later testify that from their first encounter with Camille, they noticed she was not all there upstairs. Now, Camille brings the EMTs into Thompson's apartment where they do not see anything immediately wrong. Now, to be fair to the EMTs, simply because they see the mother safely holding the child does not dismiss the possibility of child abuse. When Mr. Thompson enters the room, he is understandably confused. What are these two EMTs doing in his apartment? Not knowing that Camille had called 911, Mr. Thompson assumes they have the wrong address and asks them to leave. So far, no laws have been broken and the encounter has proceeded calmly, but that is about to change. Respondents, 4 NYPD officers, arrived thereafter in response to the 911 call and met with the EMTs who had just been inside petitioner's apartment. The EMTs reported that petitioner was upset to find them in his apartment and they left. They said they would, quote, get in trouble, close quote, if they did not make contact with and examine the baby. This is where tension begins to build. So on the one hand, Mr. Thompson was understandably upset when he found two EMTs in his living room. He has a right to be secure in his own home. On the other hand, the EMTs have a report of possible child abuse that they need to investigate. Sadly, the 4 police officers escalate the situation unnecessarily. Respondents went upstairs to petitioner's apartment unit and petitioner answered the door. They told petitioner that they were investigating possible child abuse and wanted to examine his daughter. Petitioner asked to speak to respondent's sergeant and, when they refused, asked respondents if they had a warrant to enter his home. Still, at this point, no laws have been broken. Mr. Thompson was well within his rights to require police to provide a warrant to enter his home. But look at the situation from the officer's point of view. They have a report of possible child abuse, so we can assume they wanted to make sure the child was okay. Now, with the power of law enforcement, though, comes the responsibility of using it lawfully. It was still possible to resolve the issue calmly and peacefully. However, the police would rapidly escalate this from a report of possible child abuse to breaking and entering, assault, and unlawful detainment. Respondents did not phone in a warrant. Instead, they physically attempted to enter the petitioner's home. When petitioner stood his ground in the doorway, respondents tackled petitioner to the floor and handcuffed him. Despite having restrained petitioner, respondents entered and searched petitioner's apartment over his objection, without calling in a warrant. The EMTs then went back into petitioner's apartment, examined his baby, and saw what they understood to be diaper rash, with no signs of abuse. The EMT stated that the 911 call meant that they had to take petitioner's baby to the hospital for evaluation, which later confirmed that it was only diaper rash. These 4 police officers committed crimes. While the report of possible child abuse gave them probable cause, it did not give them an exigent circumstance. An exigent circumstance in the criminal procedure law of the United States allows law enforcement under certain circumstances to enter a structure without a search warrant. It must be a situation where people are in imminent danger, evidence faces imminent destruction, or a suspect's escape is imminent. The officers had no reason to believe the child was in imminent danger or that the parents were suspects who could escape. The officers had options that would allow the EMTs to check the child without violating Mr. Thompson's rights. They could have talked to Mr. Thompson, explained they had a 911 report and were only concerned with the safety of the child. The officers could have contacted their sergeant for assistance. While they probably would have gotten their warrant if they had called for one, it would not have been a valid one, since the probable cause for child abuse was not supported by oath or affirmation, as required by the 4th Amendment to the Constitution. And no warrant shall issue but upon probable cause supported by oath or affirmation. So in hindsight, the officers' best options were to talk with Mr. Thompson or call their sergeant for assistance. Instead, they attacked Mr. Thompson without cause. See, although Mr. Thompson did refuse to grant the police entry into his apartment, he was well within his rights since they did not have a warrant. The fact that he challenged an illegal entry into his home does not give the police authority to restrain him. Mr. Thompson was defending the law while the police were the ones violating it. Now, once the EMTs examined the baby, they saw it was nothing but diaper rash. Now, I'm not sure if New York law requires a hospital examination after a report of child abuse, but such a law would violate due process since it assumes the guardian is guilty until proven innocent. This was another perfect opportunity to de-escalate the situation. Instead, the police once again escalated it. Respondents escorted petitioner out of his building in handcuffs and put him in jail for 2 days. According to respondents, petitioner's mere refusal to let them into his home without a warrant to examine his child was sufficient basis to arrest and pursue charges for resisting arrest and obstructing governmental administration. According to these 4 policemen, you have no rights in their presence. If you stand your ground when they try to violate your rights, they claim that's obstructing governmental administration. Remember, the police had no legal authority to enter Mr. Thompson's apartment since they had neither warrant nor exigent circumstance. Therefore, they were not administering a government act, they were violating it. Now, during the criminal proceedings that followed, Mr. Thompson denied any wrongdoing and declined any and all plea deals offered by the prosecution. After 3 months, the prosecution simply dismissed the charges without any plea or compromise. Mr. Thompson was free to go, but he didn't stop there. After obtaining dismissal of the charges, petitioner filed this action under 42 U.S.C. section 1983, alleging that respondents violated his 4th Amendment rights through warrantless entry of his home and by unreasonably seizing him pursuant to legal process, often described as malicious prosecution claim, referring to the analogous common law tort. Both claims survived summary judgment and proceeded to trial. Mr. Thompson sued in federal court, claiming that the officers had violated at least 2 of his rights protected by the 4th Amendment. Specifically, that the police entered his home without a warrant and seized him unreasonably. This is where things get a bit more sticky. At trial, one of the principal disputes was whether petitioner had shown favorable termination of the criminal proceedings against him, as required to bring a Section 1983 malicious prosecution claim. Relying on Lanning v. City of Glens Falls, respondents argued that criminal proceedings have not terminated favorably unless they affirmatively indicated that the plaintiff was innocent of the crimes charged. According to respondents, because the dismissal here did not affirmatively establish petitioner was innocent of the crime charged, he could not claim unreasonable seizure. According to the police officer's attorney, since the judge did not specifically say that Mr. Thompson was innocent, he could not claim unreasonable seizure. Now, if that sounds ridiculous to you, that's not a surprise, since it sounded ridiculous to Mr. Thompson's attorneys as well. Petitioner objected, arguing that dismissal of the charges was sufficient to show that the plaintiff has had the case dismissed in his favor. He pointed out that petitioner had rejected the prosecution's offer of even an adjournment in contemplation of dismissal, causing the prosecutor to unconditionally dismiss the charges. Petitioner argued that the judge is not required to say you are innocent, something that never happens. Petitioner contended that respondent's position would be absurd, requiring the people who are wrongfully and unreasonably accused of crimes to object when the prosecution attempts to dismiss the charges against them and insist on going to trial. The district court, following the precedent set by the Second Circuit Court of Appeals, found for the officers. Although in the court's opinion, they stated that the Second Circuit was wrong and set the insane requirement that an innocent person object to charges being dismissed in order to go to trial to get a verdict so they could sue for malicious prosecution. Now, while the district court also dealt with the question of who had the burden of proof, the police or the homeowner, in a case where exigent circumstances are claimed to make entry, the Supreme Court dealt only with the question of innocence in a malicious prosecution case. Justice Kavanaugh, who wrote the opinion, went all the way back to the American tort law consensus as of 1871 to justify his opinion. Held, to demonstrate a favorable termination of a criminal prosecution for the purposes of Fourth Amendment claim under Section 1983 for malicious prosecution, a plaintiff need not show that the criminal prosecution ended with some affirmative indication of innocence. A plaintiff need only show that his prosecution ended without a conviction. Thompson has satisfied that requirement here. The Supreme Court reversed the judgment of the Second Circuit Court of Appeals and sent the case back for further review. While this is a win for Mr. Thompson, it is only a battle in his war. He has not yet won his case, but with the opinion of the Supreme Court, he will at least have a chance. As often as I point out the arrogance and illiteracy of our federal courts, I think it only proper to point out when they're right as well. To all of you who have heard me talk about the need to stand your ground when government agents act beyond their law, it does my heart good to see that, at least in this case, there's a glimmer of hope that someone will receive a redress for their grievance when government officials attack. So this is good news for Mr. Thompson. No, his war is not over, but at least he's going to get a chance to fight. And that's important for all of us. Why is it? Because if you stand your ground against the illegal actions of law enforcement, and there are videos of this all over the country, at least the Supreme Court said you don't need a judge to say you are innocent in order to sue them for damages. All you have to do is not be convicted. Now, this brings us to the next step. I'm curious to see what happens now with either the district court or the circuit court with the actual charge. Did these four NYPD officers violate the Fourth Amendment? Did they violate the rights of Mr. Thompson? Now, I've reached out to Mr. Thompson's attorney, and I hope to have more information from him as this case progresses. But the important thing is, it's a next step. I also hope that should he win the day, should he win his case, Mr. Thompson will consider petitioning for criminal charges in federal court. You see, if these officers violated the Fourth Amendment, as I contend and I believe to be true, they not only caused a civil problem, they violated federal law. Title 18 of the United States Code, Section 242, makes it a crime to willfully deprive someone of a right protected by the Constitution or laws of the United States. That comes with a fine and up to 1 year in jail. Now, I'm not picking on NYPD. I'm not picking on law enforcement officers at all. But when you violate the law, you need to be held accountable. Now, this will be interesting because you have questions of sovereign immunity, qualified immunity, and the violations of the law. This is a case worth following as it proceeds, and I will. But I wanted to bring some good news to you because too often I think we're talking about the bad news. And every so often we need to recognize when something goes the way of rights and liberty. Now, if you want to find out more, if you want to follow this case with me, well, head to constitutionstudy.com. That's where I'll post any articles, any videos, anything I do will eventually end up there. You can sign up for the newsletter, and I'll send you once a month updates on what we're doing here. As I mentioned, I'm putting together my tour. I don't have any dates set in stone yet, but I'm working on them. I'm also working on a new talk that I want to bring. I think it should be interesting. I don't quite have a title for it yet, but the couple of people I've talked to it about seem very interested. So I hope you'll enjoy it. You can find out more. You can follow everything I'm doing with this tour. Just go to constitutionstudy.com/tour. As I update the page, you'll see what's going on there. And you can even hit there's a little bell on the bottom right where you can be notified when I post updates to that website. And you can see all my new articles and stuff. I'm also going to homeschool events. I've got 3 homeschool events already scheduled. You can find that again on the calendar on the website. If you're in any of those locations, if you're a homeschooler and you're going to one of those conferences, please stop by the booth. Let me know that you watch, you listen, you read the Constitution Study. I'd love to take a few minutes, shake your hand, talk to you face to face, see what you like, and maybe give you some advice of what you'd like to see. All of that there is on the Constitution Study. Now, the work I do here takes a lot of work, a lot of time, a lot of effort, and a fair amount of money. So I appreciate everybody that helps support the work that we're doing here. People who are buying books, who are buying t-shirts, people who are donating to the cause, all help to keep the Constitution Study going. It means I can provide this information to you free of charge. You can read these articles, videos, you can share them. In fact, that's the only thing I really ask you to do. You can read these articles, watch these videos, listen to the podcast absolutely free of charge. In fact, the only thing I really ask you to do is share. Take this episode, take the article that's associated with it, and share it. Friends, family, social media. Help other people to find there is good news out there. There is good information out there. Maybe they'll join you when you come back here next time for the Constitution Study.
There's one thing you have to know wherever you make your stand. Came